So to get started, today we're going to talk about asset protection by using trusts. And before we get into the actual asset protection trust part, we're going to start off briefly with just some background information about asset protection. And if you've been on some of our webinars in the past, then forgive me if this information might be not new to you, but for the new people who have joined us, I think it'll be very helpful. The overview of today's presentation, we're going to start out with some asset protection background information, which will also take us into the asset protection basics. Then we will talk about actual trust basics and talk about the differences between revocable and irrevocable trusts. We'll talk about spendthrift trusts and spendthrift clauses. We'll also talk about the ILIT, otherwise known as the Irrevocable Life Insurance Trust, and we will also talk about international asset protection trusts. Just some background information. First of all, what is asset protection? To me, asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors while simultaneously enjoying those assets. Now I know that's a long definition, so I'm going to say it again. To me, asset protection is the legal process of titling one's personal and business assets to put them beyond the reach of future potential threats and creditors. And what we do as asset protection attorneys is we help our clients protect any asset they have from any financial threat. And our clients might be lawyers, doctors, financial advisors, business owners, professional athletes, celebrities. It's really anybody who has money or any type of asset that they've worked for or inherited that they don't want to lose. And the type of assets we protect might be as simple as checking, savings, stocks, bonds, CDs, money markets, brokerage accounts. But it's also primary homes, rental real estate, vacation homes, cars, planes, boats, even shares in corporation or interest in membership interest in LLCs. And we're protecting them against any financial threat. So obviously in today's day and age, lawsuits, creditors, short seller, foreclosure deficiencies, divorce, really anything that can take away what you've worked your whole life to obtain. And what we always tell our clients is you spend a whole lifetime trying to make money. Why not spend some time thinking about how to protect it? You don't want to be in retirement age and have one car accident and lose everything. You don't want one slip and fall on your property and lose everything. So the challenge that we give to all of our clients is that for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Now, a question that we often get is, do I have enough assets to protect? And the short answer is yes. Everybody needs some sort of asset protection plan. Now, obviously, someone who has $10 million in the bank doesn't need the same plan as someone who has $200,000 in the bank. But everybody needs some sort of plan. And the example I like to give is take one of our professional athlete clients. Let's say we have a football player that signed for $50 million. Well, if they're sued for $5 million, they're not going to be happy, but they still have $45 million left, so they're going to be okay. Contrast and compare that to the everyday average person who maybe has worked his whole life and saved up a couple $100,000. If they're sued for $1 million, it's going to be catastrophic. So my opinion is that the less you have, the more you need protection. And a lot of people think, well, what if I already have an asset protection plan? If you already have an asset protection plan, that's great, but you can always build on the plan you have. Also, the laws change every single year. So we recommend just at least once a year, have your plan reviewed by an asset protection attorney. So a lot of people say, well, why do I even need asset protection? And you'll see the little cartoon in the upper right-hand corner. It's two lawyers talking, and one says, I say sue, and the other one says, anyone in particular. And a lot of people find this funny, but just like we're getting together to better educate ourselves on how to protect ourselves, the lawyers get together and talk about who are they going to sue next. Is it going to be the doctors, the business owners, the drug manufacturers? So we always have to be defensive in the world that we live in. There's over 100 million lawsuits each year, and that number is only growing. In today's bad economy, a lot of people are losing their jobs. The people who are lucky enough to keep their jobs are making less and less. Why not go to almost any corner, hire a free attorney on contingency fee, and if they win the case, get thousands of dollars, probably tax-free. Unfortunately, lawsuits seem to be becoming the next biggest business. I need to update the slide. There's actually a 1 in 3 chance you will be sued in the next year. So each person has a 1 in 3 chance that in the next 12 months they will be sued. The average person and business is sued 5 times over their lifetime. So if you have a person, the average time he will be sued is 5 times over their lifetime. And if you have a S Corp, it's really 10 times. 5 times for the individual, 5 times for the S Corp. Now again, these are just stats, so not everybody will be sued. We have clients that are sued dozens of times per month. These are just the actual stats. There's a 50% chance of divorce, and a lawsuit can cost you tens of thousands of dollars even if you win the case. So it's so easy with our legal system today to sue someone because more than likely you can get a free attorney on a contingency basis, but with that being said, it's probably going to cost you tens of thousands of dollars and years of opportunity cost to defend the case. So even if you win the case, you're really a loser because you've lost so much time, opportunity cost, and attorney's fees and defense costs. The trick is not making money, it's keeping it. It's a lot harder to keep your money than it is to make it. And again, the challenge we give to clients is that for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. So a lot of people say, well, what about liability insurance? Shouldn't that cover me? And the answer is, I think you should buy as much insurance as possible. We don't sell insurance, but it's cheap to buy and it helps you sleep at night. With that being said, understand that insurance companies are here to make a profit. They're not here to pay all of your claims. So there really is a built-in conflict of interest. My father used to say that the big print giveth, the small print taketh away. And anybody with an insurance policy knows excuse me, there's probably about a half a page of what's covered and about 65 pages of exclusions. So we think it's great, but about 70% of lawsuits are not covered by insurance. Also, your coverage may be inadequate. What happens if you have $300,000 of coverage on your car and you're sued for $1 million? You have to come out of pocket personally for that other $700,000. Your insurance company might go bankrupt. If I would have said this years ago, you probably would have told me I'm crazy, but in today's society where we have Fortune 500 companies going out of business and even banks going out of business, who's to say that the insurance company won't be next? Also, insurance doesn't cover other uninsured financial risks and divorce, and that's actually false also. I was looking on Google, and now there's one company that actually offers divorce insurance, so who knows what will be next. The point is that insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. I call it the belt and suspenders approach. 3 maxims of asset protection planning. Protect yourself before you have a problem. You always have to be proactive. You can't buy car insurance after you get in an accident. You can't buy health insurance after you get sick, and your estate certainly doesn't purchase life insurance after you've passed away. So make sure that you protect yourself before you have a problem. It is true that after you've been sued, there still might be something that you can do, but it's going to be a lot more expensive, and it's not going to be nearly as effective. Start with a very basic plan and add firewalls as needed. Start with a very simple and inexpensive asset protection plan. As your personal and business assets grow, your plan can grow. As your education on the subject grows, your plan can grow. But start simple and start inexpensive. And most importantly, don't look for one magic bullet or one right plan. Asset protection is not a cookie cutter type of practice. Any asset protection plan should be individualized and customized and tailored for your individual needs. And this is because everybody's personal assets are different and everybody's potential threats and creditors are different. So what might work for me might not work for you and vice versa. 5 killer mistakes to avoid. Number 1, asset protection is not about hiding your assets. Asset protection isn't about hiding. It's not about secrecy. It's about protection. With a good asset protection plan, you should be able to tell every single person where your assets are. They just shouldn't be able to get to them. We create every single asset protection plan with the assumption that at some point, if our clients are sued and lose, they will be under oath, either by giving a deposition or a financial statement, and you never want to perjure yourself. So, your plan should not rely on hiding or secrecy. Also, you never want to title all of your assets to straws. A lot of times people will come in my office and say, oh, don't worry, Mr. Presser, I'm being sued, but I've given everything to my friend or to my brother-in-law. This is not a good practice, and that's because your friend or your brother-in-law might have more financial problems than you. If your friend's getting sued, they're going to include your assets in his case. If your friend's getting divorced, they're going to include your assets in his divorce. So you don't want to title your assets to straws. Titling all of your assets to your spouse. We see this a lot with our doctor and physician clients. They think that, hey, the spouse might have less liability, so why not put everything in their name? And it's true, they might have less liability, but nobody's immune from a lawsuit. Nobody gets up in the morning and expects to be sued. And what happens if the wife is taking the kids to soccer practice and she gets in a car accident? What happens if there's a divorce? You don't want to title all of the assets to the spouse. You never want to commit a fraudulent transfer. A fraudulent transfer is when you have a present or potential creditor. You transfer assets out of your name for less than fair market value, and as a result, the creditor doesn't get paid. So let's take an example. Somebody is suing John for $50,000, and John only has $50,000 to his name. John takes the $50,000 that he has and gives it to his brother. The brother doesn't perform any services, doesn't give him any car, boat, condo, nothing in return, and as a result, the person suing him doesn't get paid. That is a clear and cut fraudulent transfer. There was a present lawsuit going on. He had $50,000 they transferred out of his name for less than fair market value because he didn't get anything back. He essentially just gifted it, and as a result, the creditor doesn't get paid. It's true that this is usually a civil issue and not a criminal issue. It definitely is another speed bump for the creditor, and also will be much more costly for them to go after. But with that being said, now you're bringing other people into the litigation. So if you've given the asset to your brother or to your best friend, now they can be sued for fraudulent transfer. Also, if you commit a fraudulent transfer, the rest of your plan can essentially be invalidated. So to the extent you can avoid so, you never want to commit any fraudulent transfer. Also, you never want to break any laws. One example I'll give you, our law firm does both domestic and international asset protection. And, I always tell clients there's nothing wrong with having an offshore account or an offshore trust, but there is something very wrong with having one and not reporting it to the government. No matter what type of asset protection you're doing, domestic or international, you always want to make sure that you're filling out all the proper reporting requirements with the Treasury Department, with the IRS, etc. Nothing that you should be doing should have anything to do with breaking the laws. It should be legal asset protection. So, talk about different trusts. What is the definition of a trust? A trust is really just a document that helps transfer legal title out of your name, and usually this is done for estate planning or asset protection reasons. And the way a trust is created, there's a couple different parties involved. There'll always be what's called a settlor or grantor, and those terms are used interchangeably, but that's the person setting up the trust. So the settlor or grantor is the person that's setting up the trust. They will transfer some sort of asset into the trust. Could be property, could be money, whatever the asset may be. And the trustee will actually hold legal title of the trust assets on behalf of the beneficiaries. So you have the settlor and the grantor who set up the trust. You have the trustee who holds legal title to the asset, and they're doing so on behalf of the beneficiary. And we'll talk about there's some other players involved. There's someone called a protector that you can ultimately implement, and we'll talk about that a little bit later in the presentation. Just the different types of trust that we'll talk about today. There's the revocable trust, the irrevocable trust, and then there's a domestic and international trust. The revocable trust and irrevocable trust are just as how they sound. A revocable trust can be revoked at any point. So when that settlor or grantor puts an asset into the trust and the trustee holds legal title on behalf of the beneficiaries, the settlor or the grantor can revoke what he put in there at any point. He can always take the asset out. Irrevocable is just the opposite. Once you put an asset into the trust, you cannot change anything. Most time when people come to our office with trusts, they have a revocable trust, sometimes referred to as a domestic revocable living trust. And it's a great type of trust to have for estate planning because it helps you avoid probate, but it doesn't give you any asset protection whatsoever. Any trust that you have that's revocable will give you no asset protection. Any trust that you have that's irrevocable will give you asset protection. And domestic versus international really just has to deal with where the trust is set up. So a domestic trust would be set up inside the United States, and an international trust would be set up outside of the United States. How asset protection trusts differ from regular trusts? Essentially, for a domestic trust to be an asset protection vehicle, it really has to be an irrevocable trust, because like we talked about in the last slide, if you have a revocable trust, you can revoke whatever asset you put in there. And if it's revoked, well, a judge can order you to revoke what's in the trust and give it to a creditor. So any trust that's revocable will not protect your assets. With that being said, there are some new types of trusts that you may or may not have heard of, and they're referred to as domestic asset protection trusts. And the domestic asset protection trust is really what's called a self-settled trust, which means the settlor or the grantor, the person creating the trust, can also be the beneficiary. And the domestic asset protection trust is offered probably in about, it started off with maybe 5. Now it's in about, 15 different states or so. We're not a big fan of the domestic asset protection trust. We don't set them up just because we don't think that they will work, and we don't ever want clients spending money if we don't think that the trust is actually going to do its job. The reason why we don't think that the domestic asset protection trust will work is, let's say, for example, that Alaska allows the domestic asset protection trust. Well, what if the client's living in North Carolina and has property in Texas? Well, this client in North Carolina sets up a Alaska domestic asset protection trust, and his property is in Texas. Which state law would prevail? Would it be North Carolina? Would it be Alaska? Or would it be Texas? We just don't think it will work, and there hasn't been much case law as it is a new type of trust. To go above and beyond, as you may or may not be aware, federal law always trumps state law. And there's a federal law called the Full Faith and Credit Clause, which essentially states that a judgment in one state is good and collectible in another state. So we feel that the federal law would trump any state law, thus making a domestic asset protection trust not protective. So again, if you want an asset protection trust domestically, you really have to stick with an irrevocable trust, and internationally, you can set up an international asset protection spendthrift trust, which we'll talk about later. So again, just to kind of recap, the reason why a revocable living trust will not protect your assets is because it's revocable. So anything that you, as the settlor or grantor, put into the trust, you can take out, which is great because you control it, but it's not great for asset protection. Because again, if you're ever sued, a judge can order you to take it out and give it to the creditor. Moving right along. Who should control the trust? Why you should not retain control of a trust as the settlor. First of all, if you have a revocable trust, then there is nothing wrong with you being the trustee. Okay, because it is revocable, so you can keep that control, and the settlor or the grantor, the person starting the trust, can also be the trustee as well. However, you can never be the trustee with an irrevocable trust, and that's because just by law you can't be the trustee for an irrevocable trust. It wouldn't qualify because you're retaining control over those assets. And what they always look at when you put something into an irrevocable trust is ownership and control. Are you truly transferring the asset out of your name? That's the ownership part. And also, are you truly giving up control? If you were to be the trustee, then you still have control over the asset, which would not qualify as an asset protection trust, irrevocable trust. Some other different type of trust control alternatives that you can put into place, I mentioned earlier, one of them is called a protector. And a protector is really just a party who oversees the trustee. Usually they have what's called negative powers, so they can essentially monitor the trustee to make sure they're doing what you want and that they're abiding by the trust agreement that you had originally put together. So some clauses you might see in a trust, and of course everything's totally individualized and customized and tailored for the client, but there's some clauses that you might see in the trust are that any transaction over $5,000 must have not only the trustee sign off on it, but the protector. This way you don't have to worry about the trustee running off with your money or making some decisions that you don't want them to make. Now, of course, you have to contrast this with protection. The more control you have, the less protection. and the less control, the more protection. Also, the protector, under certain circumstances, normally and usually have the power to replace the trustee. So if the trustee is not acting in the best interest of the beneficiary and is not acting pursuant to the trust agreement, certainly you can have them replaced. And we always tell people to use an independent trustee. Sure, you can use a person, but a lot of times we will recommend a corporate trustee, and that's because there's no emotion involved. If you set up a trust and you make your brother or your cousin or your friend a trustee, they might know the parties involved. They might know you as the settlor or the grantor. They might know some of the beneficiaries, and they might rule by emotion, and this scares us. So a lot of times we will recommend essentially a corporate trustee who will truly rule and govern based on the document, which is presumably what the settlor or grantor's wishes were, and not how the trustee feels just by emotion. So a lot of people ask, what is a spendthrift trust or a spendthrift clause? Essentially, spendthrift language is just anti-creditor or asset protection language that's there to protect the beneficiaries. And it might be there to protect the beneficiaries from themselves, might be there to protect the beneficiaries from creditors. So for example, a trust that does not have spendthrift language might read as follows. When my son turns 25, he gets all of the assets in the trust. That language has no spendthrift language. At age 25, the son gets all of the money in the trust. Well, what if at that point, the son is being sued for a car accident? You wouldn't want him to get the money in the trust. What if at that point, the son had some sort of alcohol or drug problem? You wouldn't want them to get the assets at that point. So you can add spendthrift language. So it might be as simple as saying that when my son turns 25, he gets all of the money in the trust. However, if there are any creditors, he is not to get anything. So that language is there to protect the beneficiary. It might also say, at age 25, my son is to get all the money in the trust. However, if he has any substance abuse problems, he is not to get anything until he's seek the proper help and has been clean for a certain period of time. So again, the spendthrift language is just there to protect the beneficiaries, from themselves and also outside third-party creditors. And you can use all of that spendthrift language to essentially protect, any of your heirs' inheritance. I want to touch briefly just on irrevocable life insurance trusts because so few people know about them. First of all, what is an irrevocable life insurance trust? An irrevocable life insurance trust is really not too different than a regular irrevocable trust, although it's normally used to hold a life insurance policy. And it's set up just like a normal irrevocable trust. There's a settlor or a grantor, there's a trustee, and there's a beneficiary. And there's a lot of benefits to having an irrevocable life insurance trust, or ILIT, from an estate tax point of view. And essentially, the reason is that, let's say you take out an insurance policy on yourself for $3 million, and the beneficiary of the policy is your son. Well, when you pass away, the insurance company will pay $3 million to your son. That $3 million will go to your son totally income tax-free. A lot of people like life insurance because there's no income tax. With that being said, there is estate tax. Now, we don't know what the estate tax will be at the time, and we don't know what the cap will be or the percentage will be, but let's say there's a 50% estate tax. Well, when you die, the $3 million will go to your son, totally income tax-free, but if there's a 50% estate tax, $1.5 million of that $3 million will go to the government for taxes because the life insurance policy was part of your estate. If you were to own that same $3 million life insurance policy inside of an ILIT, an irrevocable life insurance trust, well, now when you pass away, okay, it's not part of your estate because you don't own the policy. The policy is owned by the ILIT, the irrevocable life insurance trust. So using the same example, when you pass away with that $3 million, the $3 million is going to go totally income tax-free and totally estate tax-free to your heirs. So just in that one example, we've showed you how to save essentially $1.5 million. Obviously, the bigger the life insurance policy, the bigger the savings. These are not expensive things to set up. They might cost you a couple $1,000s or so. But a lot of financial planners who sell you life insurance don't recommend the islet. And I don't think they do it necessarily on purpose. I just think they might not be educated to it. So if you have a life insurance policy or you're thinking about getting one, certainly talk about, having it owned by an islet. Now, if you currently have a life insurance policy and it's not owned by an islet, no worries. You can always transfer the policy to the islet. There's obviously a lot of criteria that must be met, and it has to be done legally and properly. But the main thing is that there's a 3-year look-back period. So as long as you stay alive for 3 years, when you pass away, the law looks at it as if the insurance policy was always in the islet. If you pass away in less than 3 years, the law looks at it as if the insurance policy was never in the islet. And just think back to common sense. The reason the law does that is they don't want someone who's 99 on their deathbed, transferring their policy, their life insurance policy, into an islet. I want to touch briefly just on international asset protection and how an international asset protection trust works. People go and create international asset protection simply when domestic asset protection is not enough. There's no black and white numbers of when we tell a client that they should consider international asset protection. We have clients who only have a couple $100,000 who like international asset protection because it helps them sleep better at night, and it's the most protection you can have essentially in the world. We have other clients who might have $1 million who don't do international asset protection. And the reason might be that they might be in their late 80s, they don't work, they don't drive, they don't own property. So nobody has no liability, but they have as little liability as possible. We tell our clients if you have at least $500,000, you should consider some sort of international asset protection entity, not necessarily a trust that we'll talk about today, but potentially an LLC, but some sort of international asset protection. And the reason why the international asset protection trusts are so protective is that there's no U.S. jurisdiction. So in order to collect against somebody who has a properly set up international asset protection trust, you first have to sue them in the United States and win. Because if you don't sue them in the United States and win, more than likely, unless it's a special case with potential punitive awards, you're more than likely not even going to be able to ask the client what his assets are. So let's say that someone was sued in the United States and they lost and there was a judgment against them. The creditor would sit them down and under oath, of course, this is not about hiding, it's not about secrecy. The client would tell them, if of course they ask the right questions, which a lot of lawyers aren't familiar with how international asset protection works, so they won't even know what questions to ask, but let's presume they do. The client will tell them, of course, honestly and ethically, that they've proactively set up an international asset protection trust. Again, many years before. The key word here is proactively. And that trust might have been set up in a number of jurisdictions. There's about a half a dozen or a dozen good jurisdictions that trust might be set up in. Let's just take the Cook Islands just as an example. At that point, the creditor would have to go to the Cook Islands, which is in the Pacific Ocean. Last time I checked, there was, I think, one flight that left from California at, 7 o'clock, and it's about a 14-hour flight. Once they get to the Cook Islands, they're going to find out that the U.S. judgment is not recognized. So in order to proceed against this client, they're going to have to relitigate the case. In order to relitigate the case, they're going to need a Cook Islands attorney, which they may or may not be able to find because they may or may not be conflicted off the case due to the fact that the attorneys work with U.S. attorneys like myself and also, of course, the big trust companies. So at that point, the creditor might have to fly, let's call it potentially to New Zealand, which is about a 6-hour flight, and hire an attorney there. In the United States, it's very easy to hire an attorney because a lot of attorneys will take it on a contingency fee basis. So they'll take the case for free and they'll take a portion of the proceeds if they win. But internationally, more than likely, you're going to have to pay an hourly fee. So now you're paying an hourly fee for both your U.S. attorney and your New Zealand attorney to fly into the Cook Islands. Well, in order to be able to sue in the Cook Islands, and of course every jurisdiction is different, there's a statute of limitations. In the United States, Florida, for instance, if there's a car accident, you have 4 years to sue. In the Cook Islands, the statute of limitations is anywhere between 0 and 2 years, depending on a number of different criteria. And essentially, more than likely, the case in the United States took much longer than the 2 years, so they're not going to be able to sue. Let's say it's within that time period. Well, the debtor is going to probably argue that the creditor has to post a bond, a couple $100,000 or so, because if they lose, they're going to have to pay their attorney's fees. When they're suing, they need to prove the case beyond a reasonable doubt. So unlike 51% in the United States, they're going to need to prove it 99.9%, the same type of proof you would have needed to put Casey Anthony in jail for murder. And there's no punitive damages. So if it's a car accident case, it could be doctor's bills, but not the pain and suffering, which is ultimately the large punitive damages that you see in the United States. Also, hopefully, any good asset protection attorney would put what's called a flee clause in there, which would allow the trustee to re-domicile the jurisdiction of the trust assets. And while the creditor is suing you in the Cook Islands, maybe the trustee has already moved everything to Nevis, so now they have to do everything all over again. Again, today I'm just trying to give you a very broad overview of how the trusts work.